May it please the court. Attorney Douglas Rand Peacock for the Timbales, Christopher and Jenny. The central point of our appeal is really the court's decision to exclude and prevent my clients from presenting evidence that they had signed a different note at the closing. Essentially, it was their understanding that they had been first given an adjustable rate note, advised that was not what they were supposed to be signing, and then got a fixed rate note. That's what they left their closing with. We've have been able to obtain the testimony of the person who actually signed the endorsement, but was also their advisor, as he had taken this note from his place of employment. Put the plaintiff on notice, went to Pittsburgh, got the deposition testimony, so there's no lack of notice to the plaintiffs on this issue for prejudicial purposes. And then the court, on a motion in limine, chose to throw out altogether us submitting any evidence on this fixed rate note. Now,
I'm a little unclear as to what our record looks like on all of this, because the answer brief says there's no transcript and you didn't file a reply, so how do we know all of this stuff if there's no transcript of the trial?
Well, there is a record of the motion in limine order which specifically precluded us from presenting any evidence of the fixed rate note. And so thereafter at trial, we could not present any evidence, period.
And that's the problem, though, to follow up with Judge Alterbrand's question. Sometimes, I can't tell you how many times where a judge would make specific rulings in a prior motion, and then somehow at trial things change. That motion could be revisited, there's further argument. We don't have anything of that, and so that's the concern that I have in this case.
Well, there is the Williamson versus Lowe's Home Center 973 Southern 2nd 1180 case, which says when a judge makes a ruling that excludes evidence, particularly a motion in limine, you don't have the burden of having to re-litigate or bring up the objection at trial.
Well, let me jump then a little bit on that. Let's assume the record is clean on all this. This is a note that was taken over through a government, a bank failure. Is that the Dench-Doom?
No, Your Honor.
Applies here?
No, it was taken, as evidenced by the trial exhibits, which was part of the record, as part of a trust.
And let's go there. As I see the agreements, and correct me if I'm wrong, there was a pooling agreement. Was this in October 1, 2006? October 1, 2006, where there was a pooling agreement. That's where Deutsche Bank got involved. Is that correct?
That's the evidence that they submitted to the court at trial. Okay. And I'm not contesting that.
All right. And then as I understand to follow, then the Washington Mutual Bank, it failed almost like 2 years later. It was like in 2008, correct?
I believe so, Your Honor.
All right. Because at that point, when Washington Mutual failed in 2008, as I see this, it appeared that the note then already was belonging to the trust that Deutsche was part of, that pooling agreement. Is that correct?
I can go along with that rationale, that factual argument. And I state that from the standpoint of that was the records put before the court. The court could have made a factual determination on that. However, our contention is, what note did Deutsche Bank own?
I'm sorry, what was that?
What note did Deutsche Bank own? As record by Ms. Lally's deposition, which is part of the court record, there was a different note. They walked out with a physically different note than what was actually filed with the plaintiff's complaint or filed eventually with the plaintiff's complaint. And there's nothing in the exhibits attached which reference that different or just that fixed rate note. We were prevented, we would be at risk had we gone to trial and mentioned anything by the court's order about a fixed rate note. We'd have been in contempt or subject to a mistrial sanction. And I'm being very honest here. We were put on very clear notice.
You could have at least proffered something so we'd know what it looked like.
The proffered, I bet, was part of their, well, Your Honor, that's the point. If we were proffered, we would have been, the problem with these very broad points, we weren't precluded from presenting any evidence regarding the calculation of a note versus the other, which, for purposes of today's appeal, I'll concede may have been a time-barred counterclaim against the originator. But we should have still been able to say, Your Honor, we signed a different note. The note we signed was, and it's not, typically these are, oh, that's not my signature. Here we're not saying that's not my signature. That's not the physical note I signed. I know it's not because I ripped it up.
And maybe I'm confused. I had thought from the facts that there wasn't a dispute that your clients signed an adjustable rate note. It was just that wasn't what they intended to sign, and they were subsequently signed a fixed rate note. Am I wrong about that?
Yes, Your Honor. You are correct in that there was a adjustable rate note signed, and then there was a novation at the closing table where they subsequently find a fixed rate note. It was their understanding the adjustable rate note was supposed to have gone away.
How procedurally did this issue get into the case? Was there an affirmative defensive mistake, or in other words, what's the vehicle for this to become relevant at the trial?
Well, there was a denial that they'd signed. We said that they signed a similar note in the denial, first of all. I believe there was also an affirmative defense that we had signed a rate note as opposed to an adjustable rate note. And the evidence we wanted to go forward to court with was to say, again, we've got no contention that we entered into a loan, but that's not the loan we entered into. That's not the note on which you can foreclose on our property with. As we believe that it was very unclear, as Your Honor pointed out, as to when exactly did this note transfer over. Was it post or pre loan collapse of Washington Mutual? Was it transferred which note was in fact transferred to this trust? Because if a trust was transferred a note that was otherwise invalidated by a subsequent action, well, that's a problem between Washington Mutual and that trust, not my clients.
Well, is the original adjustable rate document in the record? Is that what's there?
Well, we weren't allowed, well, there are pieces of paper in that document showing the original rate note. And my clients do not recall what happened to it, so I can't say that it's not the original thing that they signed. But again, they were precluded from putting before the trial judge, which I want to stress here, because of the system in Pinellas County at that time and currently, the judge who made the ruling excluding it is not the same judge who heard the case.
Right.
So it was an absolute separation. And a different result could quite literally have come about if we were allowed to go back and relitigate this and at least be allowed to present the evidence.
But I guess what I was trying to understand was that the Deutsche Bank in this case, it's not a lost note situation. Eventually, in this foreclosure, they put into a court file a document that is signed, albeit it may be one of two, but at least the one they had possession of was the adjustable rate note, apparently.
Well, this was originally one of the funny cases that started off as a lost note count, which subsequently
becomes a different count.
Different account later.
And unfortunately, a lot of mortgage foreclosures are like that.
I understand that. However, that I can't say, nor is there evidence apparent from even the initial filing that they did have that original note. Admittedly, there's no record from the trial here, so I'm focusing my argument more on had we been allowed to properly present our evidence so that the determiner of fact could decide, was there a different note out there, an innovation, or is this the proper note that they can go forward on?
And I'm curious because, and this is, I guess it goes back to, this was a bench trial, correct?
Yes, Your Honor.
Yeah, and this is where the unfortunate thing or sometimes happens where even though you have an adverse ruling done, the day of trial, perhaps the court would revisit, perhaps this, and without knowing what was said, what was done, what was argued, it's difficult for at least for me to make a determination. Was the court wrong in its conclusion?
But, Your Honor, I mean, I can only proffer the court that being under the acts of sanctions, had we violated what was a very clear order, we did not. And we were on the record, even had we done so, we would have subjected ourselves to a reverse appeal or presenting evidence that was in contrary to the court's order. And I would just like to, unless there's other questions, can see there's the Florida Supreme Court case of Binger versus King Pest Control, which lays out this analysis that a court's supposed to at least address in its orders. 401 Southern 2nd 1310. And the big issue there is, that was a case where a party was surprised by a last-minute naming of a witness. Here, there was no such surprise, and there was any number of ways that the plaintiff could have, even if they wanted to, ask for additional time to get additional counter-witnesses, things of that sort. They were not under any prejudice by us presenting this evidence. There was no harm to the plaintiff by us presenting this evidence. There's not even a jury of lay people to get confused by complex legal issues of novation. It was going in front of a bench judge. So this order, which was effectively a summary judgment in a non-evidentiary hearing, precluded my clients from presenting, the central piece of evidence that could have easily turned the case. And that's all we've been hearing for the last 7 years, which is, if you've got fraud, if you've got something, why don't you show it? Here we had it. And at the door, we were told, nope, don't bring it in. And I think that's a fundamental denial of due process and equity in what is an equity case or foreclosure.
Okay. Save you time for rebuttal.
Good morning, may it please the court. Aaron Daniel from the firm of Kula and Associates, here on behalf of Deutsche Bank, the appellee. I believe the court has a pretty firm grasp of the case. This is simply a case where we have an inadequate record from which any error can be discerned.
Let me just stop you. I want to ask a question about
Absolutely,
the facts,
Judge.
which is the same way. That's the same question that Judge Kuzama had asked your friend on the other side. As I understand the facts, in 2006, there was a trust that acquired this note. Deutsche Bank was trustee for the trust. WAMU would have been, I guess, servicer.
That's correct.
In 2008, WAMU failed, and there was an FDIC-assisted sale to Chase, but what Chase would have acquired would have been servicing rights, not the note.
That's correct.
So I guess the implication of that to me, does Dench have anything to do with this case if the note belonged to the plaintiff prior to WAMU's failure?
Yes, Your Honor, it does. I believe that Dench has been pretty expansive over the years, and essentially those protections attach to the assets that are taken by the FDIC.
But this note was never taken by the FDIC, if I understand the facts right. This note belonged to the trust in 2006, 2 years before the FDIC rescued WAMU, right?
Correct, yes. So what would have been transferred then, Your Honor, would have been the servicing rights to those notes.
And is
so
there a
not the
case
notes
someplace that says that a transfer of servicing rights invokes the Dench doctrine?
I do not believe so. I don't think there have been too many cases since the savings and loan cases in the early 90s that have dealt with Dench Doom, certainly not in the case with servicer transfer.
Even if that case existed, I mean, what does this case have to do with the servicing rights? I mean, it has to do with whether or not
That's correct.
there's a proper foreclosure on the mortgage.
That's correct. And Dench Doom was raised in response to the motion in limine arguments, but there were other arguments supportive of the granting of the motion in limine.
What was the basis for the motion in limine? I don't quite understand.
The motion in limine's basis was essentially Dench Doom, that the...
And now you're pretty well conceding Dench Doom doesn't apply.
Not conceding that it doesn't apply, just that I haven't seen a case that has applied it in
We'd have to
this.
make new law for it to apply.
I don't think you would necessarily need to do that, Your Honor, because if you look to the case of...
It means then that the motion in limine was granted for a reason that's at least very, very novel.
Well, it's not even clear to me, frankly, that Dench Doom was raised in the motion in limine. I mean, what I see in the motion in limine is a statement that neither WAMU nor Chase was the original lender, and we can't, for a reason that's not clear to me, can't rely on what the original lender did. And then an argument, in essence, that any claim based on the fixed rate note was barred by limitations. I mean, am I wrong about that?
You're correct. The Dench Doom does not appear in the motion in limine. However, Tipsy Coachman would allow this court to affirm on that basis, and one of the cases we cited for Dench Doom actually applied Tipsy Coachman and reached that. I believe that was the Sun Chase Apartments case, which I was just citing, Sun Chase versus Sun Belt, 596 Southern 2nd 119, which basically applied the Dench Doom doctrine, holder of a note in due course from the FDIC, right, not the servicer there, but the holder. And the point of Dench Doom, if we get down to why it exists, is because no agreement between a borrower and a bank which does not plainly appear on the face of the obligation or in the bank records is enforceable against the FDIC or its S&Es. It's so that when the FDIC takes over that bank, claims don't come out of the woodwork and mess with the valuations that the FDIC is engaging in when it's selling off assets. And so servicing rights would still go to valuation of the assets. So I think you can still apply it here, but this court doesn't have to apply a novel Dench Doom doctrine theory to affirm. There's no transcript from the hearing on the motion in limine arguments. And so there's no way to discern whether abuse of discretion occurred. Additionally,
Well, the motion in limine itself has to state the grounds, and we would assume that that's what the trial court ruled on, because otherwise people wouldn't have had notice as to what the hearing was going to be about.
that's correct, Your Honor. That's correct. But again, I would resort to Tipsy Coachman and say you can still affirm on another ground. And one of those grounds, it could very well have been, Judge Solario, your question as to whether this was an affirmative defense on the fixed rate note. It does not appear from the record that the answer in affirmative defenses assert anything related to a fixed rate note. In fact, I couldn't find a single pleading from the appellants that asserted that there was a fixed rate note, and it's our motion in limine that first asserts it, and we discovered that through discovery, it appears. So I would submit that any defenses or claims, Dench Doom aside, were waived by failure to raise them in the affirmative defenses. And without a transcript of the trial, we don't know whether there was a trial by consent. And certainly our motion in limine suggests that we didn't consent. The last issue I just want to deal with is standing. They also raised standing in their initial brief. First of all, I didn't see a specific standing defense in the affirmative defenses. I believe that's also been affirmatively waived. But we have an original note that was surrendered to the court, endorsed in blank, and we have servicer testimony that that original note was held by the trust in 2006 prior to the complaint. Under the trust documents, Deutsche Bank had the authority to foreclose that note. And under this court's case in Stone versus Bank United, 115 Southern 3rd 411, that's sufficient evidence of standing. So Applegate aside, preservation aside, we submit that the record, what exists in the record, actually supports the presumption of correctness here. And we would respectfully request that the court affirm in all respects. Thank you.
Okay. Mr. Peacock?
Thank you, Your Honor.
Help me out a second. If assuming that there is a genuine debate going on as to which note would apply here, as to a claim on the mortgage, would that affect whether they were in default or merely the amount of interest that might be in the final judgment? These people defaulted sometime in the first 2 years. I don't know whether the rate was ever adjusted or whether that plays in any role in their decision not to pay on the note.
Well, depending on whether the court finds that the FDIC has anything to do with this case, and that the note...
Assume it doesn't.
Assume it doesn't, then yes, one thing would be the evidence or the interest in what was the actual damages. But Florida law is pretty clear that one has to surrender the actual note. And in this particular case, again, we're talking about a situation where our position is the first note is invalid. It was invalidated by the second note. as simple as the two parties that's come by 5 minutes later said, you know what? We didn't want to do it this way, we wanted to do it the other way, and they both agreed, signed it, and submitted it. In this case, as the evidence we would have presented showed, a document was presented to my clients who signed it, offer and acceptance. So at that point, that mortgage then ties to this second note. So to enforce that mortgage, one has to have the second note, the actual note they intended to sign, and did sign, to enforce the mortgage on the property.
Whose burden is it to inject that issue into the case? In other words, one way to think about it is plaintiff walks in, has adjustable rate note and mortgage, and says, here's what I've got, I'm entitled to a judgment of foreclosure. Is it his burden to prove or to plead and establish the non-existence of another note, or is it your burden to raise that issue defensively?
Respectfully, I disagree with plaintiff's counsel or the appellee's counsel that this issue was not raised in our answer in affirmative defenses, either by our denial and or by our affirmative defenses as to standing or holding of the note. Ultimately, it's still the plaintiff's job to show that they have the rights to enforce the note that was signed to foreclose on the property. Even where a default's been presented, they still have to present the admissible evidence. Now, I'm admitting, yes, we have an issue with that in this case, but we were not allowed to present our evidence without, any ruling on that evidence, evidentiary-wise, that would have contradicted that. Even nothing else for impeachment purposes.
Did the judge get concerned with the fact, I think there was an argument that was made, why didn't they immediately when they found out that they waited a long time, it wasn't until the foreclosure to raise this issue. Was the judge persuaded by the lapse of time in this case?
No, Your Honor. I think the judge was more persuaded by having a 3-hour trial of us going through the evidence versus the usual 15 to 20-minute ones they usually have scheduled, or 1 hour, 2 hours. I think it was more an issue of the judge didn't want to have a complicated case. And I think he was also pushed aside with the notion that we were going to be bringing complicated accounting issues, whereas we were surely trying to just put forward that, hey, it's the wrong note, if nothing else. And on that issue, assuming that there was some issue as to whether or not we could claim at this late date, and by late date I mean this time so many years into the mortgage that we've been paying the wrong amount, we may have waived those. Again, that could have been properly brought before the trial judge as a closing argument. I don't see the harm that would have happened by us presenting the evidence either way. And final issue before I close, as far as the time from when the case was started to when the case ended, we finally had a trial, there was a motion, or the case almost got dismissed for lack of prosecution. So this wasn't just simply foot dragging on the part of the homeowner.
Right.
There was a lot of time here, and the judge was sensitive that it was not just our clients who were doing it.
Okay, thank you.
Thank you. Court's going to take about a 10-minute break, and when we come back, we'll pick up with the next 2 cases. If the parties have not been told that they're in the room, our intention is to reverse the order of the final 2 cases so that the case that was tried is heard before the case upon which summary judgment was granted. All right? So we'll be back in about 10 minutes.